we will be discussing the qualification for membership of parliament. What entitles a person to be eligible to become a member of the parliament? So Article 84 of the Indian Constitution tells us the eligibility criteria. It says that the person shall not be chosen to fill a seat in the parliament unless, number one, he is a citizen of India. That is, citizenship of India is a precondition for qualification for becoming a member of the parliament. Then he shall also take an oath or affirmation pledging his allegiance to the Constitution of India and to uphold the sovereignty and integrity of India. The next important eligibility criteria is the minimum age limit. That is, in respect of the Lok Sabha, no person who has not completed 25 years of age will be eligible to become a member of the Lok Sabha. On the other hand, in the case of the Rajya Sabha, the age limit is slightly higher. Under Article 84, it says the eligibility criteria in terms of the age for a person to become a member of the Rajya Sabha is 30 years. So you can see that rightly Rajya Sabha is called as the House of Elders, as no person can become a member of the Rajya Sabha without attaining the age of 30 years. Last but not the least, there is also an additional qualification requirement that they shall fulfill any other qualifications that may be required by the parliamentary law. Hence, recounting what we have discussed, the first and foremost requirement is that he shall be a citizen of India. The second being that he shall take an oath or affirmation pledging his allegiance to the Constitution and promising to uphold the sovereignty and integrity of India. The third is the eligibility criteria of age, which varies as 25 for a member of Lok Sabha and 30 for a member of the Rajya Sabha. And finally, he has to possess any other qualifications that may be specified by Parliament through law. In exercise of this power, the Parliament of India has enacted the Representation of People's Act, which imposes certain additional requirements for a person to be eligible to become a member of parliament and also to contest in parliamentary elections. So it goes without saying that there is a requirement to fulfill these conditions that are specified under the Representation of People's Act as well. The next important aspect of our discussion is disqualification. We know what are the qualifications for membership of parliament. What are the disqualifications? That is provided under Article 102 of the Constitution, which says that a person shall be disqualified from being chosen and from being an MP, first and foremost, if he holds an office of profit. What is office of profit? The Constitution deems certain posts, certain offices as creating a conflict of interests. So any person who holds an office of profit as specified by the law of the land will be disqualified from holding membership of the parliament. So such office of profit should be held either under the state government or under the central government. So if a person does not hold office of profit, he is free to contest and hold membership of parliament. The next important requirement is, or next important disqualification is unsoundness of mind. A person of unsound mind who is declared to be so by a competent court is said to be disqualified from his membership of parliament. The third disqualification is a person being an undischarged insolvent. Insolvency acts as a disqualification for membership of parliament. Fourthly, a person who is no longer a citizen of India or who voluntarily acquires citizenship of a foreign country or he pledges allegiance to a foreign nation. In all these three circumstances, the requirement of citizenship and allegiance to the Indian constitution and the Indian nation is lost. And hence, a person who is not a citizen of India or who has voluntarily acquired foreign citizenship or who pledges allegiance to a foreign state loses his right to hold membership of parliament. Apart from this, there are also certain other disqualifications that may be imposed by the parliament. So a typical case of disqualifications include the Representation of People's Act, which says that persons who are found guilty of certain particular socio-economic offences, such as promoting enmity between various groups, dowry harassment, and various other socio-economic offences including adulteration and other economic offences, they are disqualified for a specific time frame from contesting in elections under the Representation of People's Act. So under these provisions as well, there may be a bar upon persons being members of parliament. Last but not the least, we have disqualification on the ground of violation of anti-defection law. What is anti-defection law is an important question that will be answered now. Anti-defection law or defection, the concept as such, pertains to switching over of political parties by members of parliament. That is, electoral candidates who contest in elections under the support or under the name of a particular political party, once they win the elections, are not permitted to switch over to other parties. This switching over of parties is known as defection. Anti-defection law aims at preventing unprincipled and unethical defections, which is a persistent problem that is plaguing Indian electoral politics. Very often we hear stories of political horse trading, how members of parliament and politicians are being paid to switch over parties. Many unscrupulous, unethical and illegal means and measures are being resorted to get people to switch over political parties or to vote against their own political party. Anti-defection law aims to prevent all these unprincipled and unethical defections by disqualifying people who engage in such unethical and unscrupulous practices. This was introduced in the backdrop of growing menace of anti-defections or rather defections that was found in India in accordance with the 52nd Constitution Amendment Act of 1985, which creates Schedule 10 of the Indian Constitution, which details provisions pertaining to anti-defection law. So when can anti-defection law be attracted? Primarily, and to sum it up, when any person voluntarily gives up membership of the political party to which he belongs to. That is case number 1. When a person who is a member of a political party wins elections and is representing that political party chooses to give up his identity or membership in that political party. Number 2, whenever a particular member of parliament votes against the directions of the party concerned without obtaining prior permission. So as party politics is also ideologically entwined, inevitably parties may require members to toe the line of the official ideologue. Hence, very often there may be directions to vote for or against a particular motion, a particular law or a particular bill. So whenever there is a direction from the party in which you are elected to vote in favor or against a particular bill, motion or decision, and you choose to act otherwise, you choose to disregard the directions of the party without obtaining prior permission, that makes you liable for disqualification under anti-defection law. The only exception is in respect of condonation. So even in the absence of getting prior consent, after voting against the directions of the party, if the party in question pardons your action then you are saved from anti-defection law. In all other cases wherein you give up the membership of your political party or you vote against the directions of your party, you will be in a position to lose your seat as a member of parliament in accordance with anti-defection law. There is one particular exception to the principles of anti-defection law. That important exception is what we call as merger rule. Under Schedule 10, whenever a group of individuals exit a party and the number of people exiting the party exceeds a certain threshold, they are saved from anti-defection law provided they merge into another political party, commonly known as the merger rule or the two-thirds rule. So what it means is that, let us take an example. There are 30 members of parliament of X party. 20 of these members of X party who are MPs choose to exit the party. As per this rule, because they form two-thirds of the total membership, they are protected from disqualification. However, if 10 members of parliament out of the 30 choose to exit, they will be disqualified. So this is the two-thirds merger rule, wherein whenever more than two-thirds of a particular members of parliament of a party exit and form a new group or merge with an existing group, they are protected from anti-defection law. So this is the merger rule. Finally, coming to the concept of vacation of seats. Until now we have discussed qualifications and disqualification. Vacation of seats under Article 101 details the circumstances under which the seats of members of parliament stands vacated. Firstly, the constitution prohibits holding of simultaneous membership of both houses of parliament. What it means is that no person will be permitted to become a member of the Lok Sabha and the Rajya Sabha simultaneously, and he necessarily has to give up membership of either of these two. The second similar principle is that no simultaneous membership of Parliament as well as state legislative assembly. No person is permitted to hold simultaneously a post of MP as well as MLA. If he does so, if a person is holding both the post of MP and MLA and he does not resign the post of MLA, the law says that automatically after a certain time frame he will lose his membership of parliament. Apart from this, what are the circumstances under which the seats of members of parliament stands vacated? As we've already discussed, whenever a particular member of parliament is disqualified in accordance with Article 102 of the Constitution, he automatically vacates his seat as a member of parliament. Last but not the least, vacation of seats as member of parliament is possible through resignation made by the MP. Under Article 101, it categorically states that a member of parliament of either the Lok Sabha or the Rajya Sabha is free to resign by writing under his hand to the presiding officer of the house concerned. That is, a member of the Lok Sabha, if he intends to resign, has to write to the speaker. A member of the Rajya Sabha who intends to resign has to write to the chairperson of the Rajya Sabha. If he does so and the resignation is accepted, then his seat stands vacated. Now, coming to the next important aspect of our discussion of the Union Parliament, who runs the business of the Parliament? Who is the boss of the Parliament, so to speak? It is the presiding officers of the Parliament. So both houses of the Parliament, that is the Rajya Sabha and the Lok Sabha, are run and they are headed by a particular constitutional functionary, that is the chairman and the deputy chairman in the case of the Rajya Sabha in accordance with Article 89. Article 89 tells us that the presiding officer of the Rajya Sabha, that is the chairman, it is none other than the vice president. It provides that the vice president of India shall be the ex officio chairman of the Rajya Sabha. It means to state that whoever occupies the post and the chair of the vice president becomes automatically the chairman of the Rajya Sabha. To assist the chairman, there is appointed another person by name deputy chairman who will fill any situation wherein the chairman is unable to attend to his duties. Next, coming to the presiding officer of the parliament. In the case of the parliament, Article 93 categorically tells us that the speaker is the presiding officer. That is, the speaker will head the parliament and he is assisted by another person by name deputy speaker. So the speaker and the deputy speaker are responsible for running the parliament, particularly the Lok Sabha. Next important aspect that we will be discussing is how do decisions be made under the Union Parliamentary Framework. How are decisions made under the Union Parliamentary Framework? Article 100 Clause 1 of the Indian Constitution tells us about voting. What is the voting that is required for a particular motion, bill or a legislation to be successfully passed? It tells us that whenever there is an ordinary law, decision or motion, all decision making will be done by a majority of those who are present and voting. It essentially means that all ordinary decisions, bills and motions are decided by a simple majority. It means that there are certain circumstances wherein under the constitutional framework explicitly a higher majority may be specified. Take for example constitutional amendments under Article 368. They necessarily require a 2/3 majority. On the other hand, there is the question of equality of votes. What happens in the very rare and unlikely situation of a perfect tie? A particular bill is being mooted, a particular bill is being proposed. There are 50 members of parliament who support it and 50 who oppose it. So in this case, we have what we call as an equality of votes. The constitution gives us an answer for this situation as well. It tells us that whenever there is an equality of votes, there is a perfect balance between the yes and the no's, then there is a power in the hands of the speaker or the chairman of the Rajya Sabha to cast what is known as the casting vote. That is essentially a tiebreaker. So generally speaking, the presiding officers of the parliament are not empowered to vote upon decisions of bills or legislation. So this is one of the rare occasions wherein there is a power to impose or to cast a casting vote to arrive at a decision. Next important aspect pertains to the concept of a quorum. What is quorum? Under legal parlance, the term quorum means the legal minimum number of members of parliament who are required to be attending a particular meeting for that meeting to be valid. So it is the minimum attendance requirement, if I may put it that way. So without this minimum number of members of parliament being present, no legislative business can be carried on by the parliament. This is known as a quorum requirement. The constitution says that the quorum requirement is 1/10 of the total membership of the house. So depending upon whether it is the Lok Sabha or the Rajya Sabha, at least 1/10 of the total members have to be present in all times in any given day for a meeting to be validly held and business to be carried out. Next comes the important question of what happens when there is a deadlock. As we already know, in respect of all laws of ordinary nature, motions and decisions, there is an importance for or equal importance for both houses. So no ordinary legislation will become valid law unless and until it is accepted by both houses of the parliament. So there arises a situation wherein there may be a deadlock which arises out of a disagreement between the Lok Sabha and the Rajya Sabha. The Lok Sabha agrees to a particular proposal, the Rajya Sabha rejects it. How long can you continue this deadlock? There may be certain situations when there is a need to break this deadlock. The Constitution gives us answers in the form of Article 108 of the Constitution, which enables the President to call for a joint sitting of both houses of the Parliament under one common hall. That is, with the purpose of breaking the deadlock, a separate special meeting is called for wherein both members of the Lok Sabha and the Rajya Sabha sit together and they arrive at a decision. The important point to be noted in this case is that when this joint sitting happens, number one, it is the Speaker of the Lok Sabha who presides over the House and not the chairperson of the Rajya Sabha. Number two, the voting will be carried out by adding up both these houses. So what it essentially means is that in a joint sitting, there is an indirect upper hand for the Lok Sabha who outnumber the Rajya Sabha by a 2:1 majority. As you already remember, the number of members of the Lok Sabha is 545. On the other hand, when you look at the Rajya Sabha, it is 238, right? So when we add other members, it comes to 245, right? So you can see clearly that there is a 2:1 majority, wherein which under a joint sitting, there is an indirect upper hand for the Lok Sabha. So this is the essential notion. And a joint sitting, please bear in mind, is a rarity, and only in 3 instances in India's constitutional history has a joint sitting been called for and a law has been passed under the joint sitting mechanism. So it is a exception rather than a rule. That is to be borne in mind. Last but not the least, when the parliament functions in the exercise of its powers and the exercise of its business, there are certain powers, privileges and immunities that are conferred upon the parliament. So in order to ensure that the parliament is able to carry on its business properly, effectively and without any hindrance, there is something known as parliamentary privilege under Article 105 of the Constitution, which confers members of the parliament the freedom of speaking freely in the parliament without any fear of reproach or any other form of reaction. So what it means is that conduct that is occurring within the walls of the house are subject to the rule of the house in itself. That is, the parliament is a well in itself, and whenever anything goes wrong, who has the authority to decide and judge? It is the speaker. And no action can be taken in respect of what you call as the speech that is made in the context of a parliamentary proceeding. There are parliamentary privileges, protections and immunities, and these immunities extend to the prohibition of arrest of members of parliament for a time frame before and after the completion of the proceedings of the parliament in civil matters. So there is free speech, there is protection from arrest in certain cases, there is also various other privileges and immunities that are conferred upon the parliament to ensure that the parliamentarians are able to freely discharge their duties and fulfill their obligations under India's constitutional scheme. Last but not the least, we will not now be discussing on the position of the Lok Sabha vis-a-vis the Rajya Sabha. Is there any power imbalance between the Lok Sabha and the Rajya Sabha? Yes, there is. Under India's constitutional framework, we can clearly see multiple provisions wherein a slight upper hand is given for the Lok Sabha. The reason being the fact that the Lok Sabha is directly elected by the people and it has the popular backing. So essentially the Rajya Sabha is seen as a safety valve, a checking mechanism, and in certain specific matters, particularly in money bill. In any bill which is in the nature of a money bill, an outright upper hand is given to the Lok Sabha, and the Rajya Sabha has very limited powers of purely recommendatory nature in respect of the money bill. So these are certain instances wherein you can see that the Lok Sabha is being given an upper hand. Similarly, we also know that the principle of collective responsibility, wherein the ruling government is held to account, that is only in the house of the people. It is only the Lok Sabha that holds the ruling government to account, and they are collectively responsible only to the Lok Sabha and not to the Rajya Sabha. So these are some of the instances wherein the Lok Sabha is given an upper hand in respect of the Rajya Sabha. But that does not mean that the Rajya Sabha is a paper tiger. There are many important aspects, particularly in the context of creation of All India services, as well as in certain circumstances wherein lawmaking power is to be granted to the Union Parliament. It is the Rajya Sabha which has to trigger the process. So in that sense, Rajya Sabha occupies a pivotal role in terms of India's constitutional framework. So with this, we broadly wind up our discussion upon the Union Parliament, which comprises of the Lok Sabha and the Rajya Sabha. We have to bear in mind at the end of the day, when we speak of parliamentary functioning, the power to summon and prorogue both houses of the parliament rests in the hands of the president. However, the power to dissolve the Lok Sabha alone exists in the hands of the president, and the Rajya Sabha can in no circumstance and in no case be dissolved, as it is a permanent body. With this, we wind up our discussion on the Union Parliament, the Lok Sabha and the Rajya Sabha. I hope you could be in a position to comprehend this discussion. Thank you. Happy learning.